Welcome back to the Retire in BC podcast. I'm Ben, and today we're tackling a topic that nobody really likes to think about, but everyone probably should, and that's estate planning. A lot of people think it's just about writing a will, but it's so much more than that. It's about making sure your wishes are honored, your loved ones are protected, and the money that you've worked hard for doesn't get wasted or lost in legal delays. Today, we're going to walk through estate planning from start to finish, what happens if you die, how to plan for incapacity, and what steps you can take now to make things easier for everyone you leave behind.
But let's first talk about what happens if you die without an estate planning, without a will, without all the things that you should have. Um, uh, what happens in that case? Well, actually, what happens regardless is an estate gets created when you pass away. Anything that has a beneficiary named to it, that whether you have, well, actually, I guess, yeah, whether you have a will or not, if you have a beneficiary listed, you have done a little bit of estate planning. Those beneficiaries are going to get those assets. If you have something in joint name with somebody else, you've also done a little bit of estate planning without even knowing it, because they're going to get those assets. But your estate is technically what's left over after that happens. And if you don't have a will and you haven't done that estate planning, then you're maybe going to have a problem.
Yeah, well, and I want to point out too that it's basically all assets, especially all financial assets, but it's also going to include liabilities, right? So any debts that you have, stuff like that, those are going to go to the estate also. And when you pass away, your estate is created. All of your assets that haven't otherwise moved on to another party now belong to the estate. Essentially, then there's a deemed disposition of all assets. The government treats it as though you've sold all of those right away, and if taxes apply, then they apply on those. And then after all of that is taken care of and it goes through the estate, it gets distributed however, like assuming you don't have a will again, it gets distributed however your province has said that it would go through. So in BC, at least, that follows what most people probably want, in that if you have kids, it goes downstream to them. If you don't, like maybe it goes upstream to the parents and then out to siblings and stuff like that. But a lot of the times I've talked to people who don't want it to go that way. They want to have some control over that, how that happens. You also wouldn't have control over who takes care of administering all of that, who the executor is, if you've got minor children, who's going to take care of them if you pass away, and just generally speaking, how do you manage all of those tax implications? So really, all of those together are what estate planning involves.
Actually, Ben, I think I would challenge you a little bit on the comment that in BC, it's probably what you're going to want to happen anyhow, because in my experience, like the legislative, last time I looked, the legislative breakdown was a certain percentage would go to your spouse, but a certain percentage would go to your kids. And what most of the people I talk to want is they want it all going to their spouse. And then when their spouse passes away, they want that all going to their kids. But they don't want to divvy it up right away when they pass away. And the BC legislation, last I looked, that's how that set that up. And every province, it's a little bit different. But really, at the end of the day, you just don't have any control over it
Well, yeah,
if
exactly.
you
That's the
don't
point,
have the
is that
will. Yeah,
it's
that's right.
the province putting
Yeah,
together those rules, not you,
yeah.
not your wishes, for sure.
And also sometimes by just thinking about it and doing it right, you can save some taxes. You can certainly make it a lot simpler and cleaner and easier for your beneficiaries, for your family. So we are huge proponents of making those estate plans.
Mhm.
And again, like Ben pointed out, that's not just a will. It's the will, but it's also making those beneficiary designations. It's also knowing who whether you've got an asset in joint tenancy or joint with right of survivorship, because that's a bit of a difference. It's also making sure you've got powers of attorneys in place and the right insurance in place. It's the whole kit and caboodle is the overall estate planning.
Hmm. Hmm.
So maybe we want to just talk briefly about wills.
Yeah, perhaps. And I think actually kind of before that, I think it's just useful to have an example. So like let's say I were to pass away next week sometime, and just kind of take a look at a couple of different areas. I've got a tax-free savings account. I could hypothetically name a beneficiary on it. So I could name you, and if I were to pass away, it would go to you. Like we talked about, everything else. So I just recently bought a townhouse that I'm not going to name a beneficiary on. I'm not going to list you as the joint holder. Sorry, Dad. Um, so that piece would make up part of my estate. Anything that flows through the estate. So if it hasn't had a named beneficiary or been jointly held, it's going to flow through my estate, right? And so the purpose of the will is to describe that which comes through the estate. How do you want that distributed, right?
So actually that's a really good point. Yeah, because there's quite a few assets that you can't name a beneficiary. And so yeah, I think actually um I would describe it as what happens when you die is you sort of have three buckets. Bucket number one are those things with beneficiaries, life insurance, RSPs, RIFs, TFSAs. What have I missed? Well, locked in accounts, different versions of those same accounts. Those go straight to the beneficiary. If you haven't named the beneficiary, they will go to the third bucket to the estate. But if there's a beneficiary name, that's bucket number one, and it just goes out to those people. The second bucket are those assets that you have in joint name. Typically, that would be a house, might be some bank accounts or savings accounts, some investment accounts. Um, Maybe a vehicle, although often those are typically just in one person's name. But anything that's in joint name, and in many cases these days, it's automatically assumed in their paperwork that it's joint with right of survivorship, and that is distinct and different from joint tenancy. But typically that's what it's deemed to be. So anything that's joint like that goes to the joint survivor. That's what that means, joint with right of survivorship. The survivor gets that right to have the rest. Everything, so that's bucket number two. Bucket number three is everything that's left over. And so that is definitely what we're talking about here and now.
Yeah, and so that's where when I write a will, I'm saying that, okay, everything that's going into that third bucket, which is my estate, I have a certain idea over how I'd like that to be distributed, whether I want it to go all to one family member, whether I want some to go to friends, whether I want some to go to charity. If so, what percentage? Do I want 5 grand to go to charity and then 20% to go to my parents and then the rest to my siblings? So there are kind of any number of different ways that you can adjust that, and it can be very flexible in terms of those percentages or specific dollar amounts that are coming in through the will. You're also deciding who do I want to administer that as the executor. So if I think, for example, my brother's a reasonably responsible person, he'd be good at administering my estate. Maybe I don't want to pick my parents because they're older than me and might predecease me. Those are some
Probably,
things that you
hopefully.
can, yeah, probably, hopefully. Those are some things that you can think about and list out. Um, and crucially, too, I had highlighted it before, but I mean, I don't have children. I don't have minor kids. If I did, I would want to give a lot of thought actually to if I pass away and they're still young children, who do I think would be a good person to take over as their guardian, right? So that's
You,
another really crucial component.
actually, we're going to talk about that later on. We've got it on our agenda here to specifically talk about guardianship. But I have to say, when you guys were younger, and having talked to quite a few other clients about this, that actually is often the most difficult of all the different pieces of it. That is the most difficult, and I found it's often one of the reasons that many people don't have a will because they can't satisfy that one piece. Don't let that stop you. Worst case scenario, just name some random individual that you kind of like and plan to change it later, but get the will done, right? Don't let that stop you.
Yeah. Well, I guess the question again is, do you want to have an awkward conversation today and make a fairly hard decision, or do you want to let the government do it?
Right. Yeah. Yeah. No,
Right.
good point. Good point.
And for me, I know,
Yeah.
7 days a week, which one of those I'm choosing, right? So,
Exactly.
um,
Exactly.
yeah.
So, one of the things that we like to add to, or not add to a will, but have in addition to a will, is something that we've created at IPC, something called a will companion. And I love these instruments. They're not a legal document, but what they are is it's a data collection tool. It's a summary of all the information that your executor, and maybe your beneficiaries, um, will want and need in the event of your passing. And it's going to make their life way, way, way easier. And also it's going to ensure that they actually find all the stuff, because one of their jobs is sometimes is to try to find where did you hide this password, or where did you hide, this, yeah, where's the book with all the money in it, or whatever it is, right? And so a will companion is a place where you can put that, and ideally you have one that's password protected. We have a great tool that's exactly like that. You're welcome to it. All of our clients, a number of years ago, were sent a physical, uh, USB stick, password protected, with one. And so we highly recommend that people get those. They're not required. They're not a legal document, but they make it so much easier for the ones you leave behind.
Well, and I think in particular too, it's partly passwords and things, but also partly just which accounts do you have? Where the heck is all the money?
Yeah,
Uh,
yeah.
Because I could see like a lot of the times, and we have seen this, just the next of kin doesn't know about this little account at that bank that was over there. Especially these days when all of the documentations and things like that are digital, statements and stuff like that. It's nice to go through this exercise. I'd probably recommend every year or two, actually, although no one's going to do that. But to just list out, here are all of the assets that I have, and if I were to pass away, this is what you should know about for the next of
But
kin.
that's what's great about the new digital will companions. It is, to do that every year and write it all down on paper is really onerous.
Hmm.
To do it once a year and look at last year's PDF and overwrite one or two things is not that onerous. And so it is something that you can do every year, or at least every other year. Yeah, yeah, for
Yeah.
sure.
Yeah. So tacking on then to the will conversation, I mean, we've already touched on other ways with beneficiaries and joint right of survivorship. Those things happen very quickly and they happen privately and without really any other implications. I mean, in the case of an RSP or something, there's still some tax implications there,
So,
but
so you mean you're talking about when somebody has named a beneficiary
yeah,
to an RSP, a RIF, a
yeah.
TFSA.
And
Okay.
by contrast, going through the will, not that this is strictly speaking a bad thing, but going through that will, that can take a little bit longer, especially if it's a complicated estate. It can take up to a year or two, even for the estate, or
Or
longer. Uh,
multiple years, yeah.
right? I'd say usually it's quicker than that, right? Most estates are going to be done
You in a
in
few
in
months.
6 months, three
Yeah,
months, something
yeah.
like that. But just it can be a little bit more complicated. Um, We'll talk a little bit about what the executor's actual duties are in there, but also just wanted to highlight when you go through there, um, some of the privacy things. It's not as private as going through other stuff, and you also might face some probate fees. So just kind of want to touch on those. They're kind of downsides, but they're also just kind of the nature of the game. Part of going through the will is that you have to go through these steps. So which one should we start with, Arnold? What do you think?
You want to talk about executors?
Sure,
Or
let's
so yeah. So what one common misconception that I hear quite often that I just want to make sure we address is, um, people will say, well, my power of attorney will look at that, will deal with that after I die. And it's important to understand that if you have a power of attorney, that's great. That's really important. And we're going to talk more about the power of attorney later. But when you die, that power of attorney has no power. It's done. It's done and over with. When you die, it's the executor that you've named in your will that's going to deal with your money. So if you have a power of attorney, but you don't have a will, if you haven't named, or well, if you have a will, you will have named an executor. I mean, I can't imagine that ever getting missed. But if you don't have a will or you don't have an executor named in it, then nobody is appointed to deal with your money after you die. The
Mhm.
power of attorney stops when you die. Important to understand that. So the executor's job is to look at your will and make that happen the way that you want it to happen. Um, well, first, to make sure that everything is done legally, and second, to deal with it according to your wishes, right?
Yeah.
So they're not legally allowed to give their cousin 100 grand if you didn't say give them 100 grand. Now, they have the signing authority to do that, right? We can all break the law, but they're not allowed to do that. And if your beneficiaries, or if that was to happen, your beneficiaries would complain, and the courts would bring that money back. But so you do want to make sure you've got somebody that you trust, because they do have a fair bit of power and authority, but they are bound by what your will says, and it's just their job to make that happen, to pay your bills, to find out all the money that you have, and to divide it up and send it to wherever you said you want it sent. And sometimes there may have been maybe some discretion there that you give them, but usually it's fairly prescriptive.
Yeah, well, it's someone that you trust and also that's fairly responsible with money, and it helps if they're a little bit savvy with this kind of thing, just because it is a little bit more complicated than just distributing the will as per how you decided. It's okay, well, first we have to locate the will. We have to make sure it's the most current version because you should be updating your will regularly. We have to locate all of your assets, all of your debts. That's where something like the will companion comes in really handy. So it's a tool to help the executor find all of the assets, locate it, pay any applicable taxes that have to come in, and then yeah, like Arnold said, they're having to follow the law and then also follow your wishes for with what's remaining in here. How does that go out to your beneficiaries and all of that?
Well, and it's worth pointing out the executor doesn't have to do all this stuff. They're responsible for making sure it all gets done. And so oftentimes, in fact, I would say it's the norm for an executor to hire a lawyer to do much of this stuff. The executor has to be the one to sign the paperwork. They're the ones with the legal authority, but usually they're not going to be the ones applying to the courts for probate. They're going to hire a lawyer to do that. Also, even in fairly simple estates, it's quite common for the executor, if there's multiple siblings that are beneficiaries, to say, hey, gang, you're all going to help make this stuff happen. Again, the executor is the one that has to sign the documents. He's the one responsible, but he doesn't have to do necessarily all the work. He can rely on, or she can rely on his siblings or other beneficiaries or other people in the family to help
Yeah.
or get legal help.
Yeah, well, and just to tack on to that really quickly as well, like we're saying it's complicated, we're saying it's all this work. Two other ways you can handle that. One, you can say, you know what, they should probably be compensated for all of this work that they're doing.
Absolutely.
I think it's reasonable for them to get paid X dollars per hour for what they're putting in. So that's totally something you can do. And number two, if you're not able to think of someone that you know that would fit in this role, you can always name a lawyer to be the executor and to fill that duty. So
And that's
yeah,
that's a very common thing to have done,
yeah.
lawyers and trust companies to get them involved.
Yeah, for sure. So what else? We were going to talk about probate quickly as well. Just that there's a legal process to make sure that the will is valid, essentially, and that's what probate is. It's basically you get dinged a little bit of the estate, and that has to get paid to pay the probate fee. It's sometimes I see people, I think, overstress about probate.
I would agree.
Now, that being said, it's not nothing. Like in BC, I think it's 1.4% of anything that goes through the estate that over a certain threshold, which I think is 25 or 50 grand or something like that. So that's not a tiny amount. That is a real dollar figure that gets taken, whittled out from the estate. But at the same time, it's kind of just the nature of the game. Um, I have seen a lot of people pull out their investments 2 years early because they don't want to pay probate, and they've missed out on 25 or 30% of growth in the investment because they don't want to pay the 1.4% probate fee. So just word of caution there in terms of how to do that.
Yeah,
But
I'd agree. Often the cost of trying to avoid probate is greater than the actual probate itself. In most cases, not all cases, there have been a few where I've said, hey, you should do this to avoid probate, but it shouldn't be the main focus. Uh, it's not on things where you've named a beneficiary. So, your RSPs and your RIFs usually and your TFSAs, those can be big amounts and they can flow without that, but it will be on the value of your home or savings, um, uh,
well, and I think too
minus
we
any
should
debt, I
maybe
should
we should
say,
maybe
right?
just circle back and say like, why is this needed? Why is it there in the first place?
That's a
Um,
good point. Yeah.
and just, I mean, the idea is if you're the executor and you're going to the bank and you're saying, hey, the deceased person had 200 grand in your bank, we need to pull it out and pay out the estate. The process here is that the bank wants to say, what steps have you taken to prove that the person's dead, first of all, and B, that the will is valid and you're doing all of the right steps. So that's kind of what probate is about. It's going through the court to validate the will.
Yeah, exactly. Yeah. Probate is the court stamping the will saying this is legit. It's okay to act on this. And it gives banks, mutual fund companies, brokerages comfort to know that, hey, it's okay to follow this executor's instructions, right? So if the dollar amounts are small, often those entities won't demand it. But as soon as the dollar amounts get to any size, they want to see it. And in fact, actually, I've even seen cases where um, large, like people were named on beneficiaries and they still wanted a copy of the will just to ensure that there wasn't um, a discrepancy between the will and the beneficiary designations when the dollar amounts are large. Um, uh, these days with more and more fraud happening, they want to be extra careful. So,
Mhm.
so yeah, don't be too afraid of probate. It's there for a reason. There is a cost, but it's not in the big scheme of things. It's not that astronomical relative to the value of the estate.
Yeah. And I think probate kind of takes us nicely into the next thing that I wanted to mention, which is just that, at least in BC, and I think it works this way in other provinces as well, not 100% sure about that, but in BC, a will becomes public record after it's
Yes.
probated,
Yeah.
right? And so if you're concerned with privacy and you don't want, not that I think people are necessarily looking up their neighbors' wills and whatever, but if you're quite concerned with privacy, it might be a better solution to start naming beneficiaries on your accounts, getting life insurance as an estate planning tool, things like that. Because once it's gone, anything that has gone through that will and gone through probate, that is public record and people could search it up.
Yeah, that's correct. Yeah. 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 I don't know about other provinces, but certainly, yeah, here in BC, that is definitely the case.
Yeah. Yeah. Um, yeah. What's next then? I think that's kind of mostly the wills and the dying with and without a will and all of that stuff. I think we will talk about powers of attorney in a second. I want to chat about that a fair amount. But also just on the topic of passing away and like what happens there. A lot of people, this is becoming more and more popular, and I think it's a great idea, is just pre-planning the funeral expenses and also prepaying potentially. That's a lot of P words, but the funeral expenses, giving some thought ahead of time as to what do I want that to look like for me if I were to pass away? How would I want the service to look? Would I want to be cremated or buried or what have you? So these services are becoming more and more popular, which I think is a great thing. Again, just lets you plan ahead and also then have that conversation with your family.
No, I agree actually. The where was I going to go with this? The From what I have seen, and by the way, I have not done this yet, but from what I've seen in other people is when um, when somebody is grieving and they are trying to make those arrangements, there's a far greater tendency to spend more because you're grieving and you're looking at this and you want that nice stone. And when you're doing it yourself and prepaying it, there's a greater tendency to say, just give me a pine box, I'll be okay. Right. And so people tend to spend less, quite a bit less, when they decide on it themselves. And it does remove a lot of pressure off the survivors.
Hmm.
There is also a slight financial benefit for certain of those expenses. The funeral homes um, are able to put that into accounts where you earn a little bit of money, but you don't pay tax on it. And so it actually does grow. It's not a lot, but um, and it, I believe, you know what, I'm not that familiar with the exact arrangements, but I believe it can't be an amount to cover food, but it can be an amount to cover your arrangements and the casket and all that stuff. So I, you know, the
Hmm.
dollar amounts aren't that big, but there is a little bit of a financial incentive to doing that as well.
Well, and I think the finances are one aspect of it, but probably the bigger aspect on this side is just the peace of mind,
Yeah,
you getting the arrangements that you would like.
yeah,
And then, especially for the next of kin, if you were to pass away, the last thing I want to be doing is planning an event of any
right,
sort,
yeah, yeah.
right? Like it just would be a lot easier if some of these things had been thought of ahead of time and laid
Okay,
out.
I'm I'm
So,
I'm gonna go on record, book out a pub, take it for the night, buy everybody drinks,
yeah,
just have a good time. There you
there
go.
you go.
That's that
Yeah,
that's
perfect.
that's that's what I want. There you go.
Perfect. And so then just circling back to, I mean, we've touched on it once or twice, but um, one aspect, especially as it concerns to the privacy going through the will, is just that I do sometimes like the idea of using permanent life insurance as an estate planning tool. So let's suppose you've got the family cottage that's going to be a deemed disposition. If you sell your house, it's a primary residence, so you get the primary residence exemption. It's not taxable. If you sell the family cottage or the rental property or whatever, like let's say there's a potential $300,000 tax liability over there that the estate's going to have to pay, you could buy life insurance that pays out 300 grand so that when you pass away that is there to cover the potential taxes. So don't want to spend too long on insurance and stuff, but just thought I'd mention that can be an appropriate tool when it comes to those kinds of conversations.
Certainly, anytime there's something that you really, really want to make sure that the kids or grandkids can hang on to, and you're worried about the tax liability being too much and them not being able to keep it because of that, um, in those cases, that makes tons and tons and tons of sense to do.
Yeah.
Um, and I think that's actually a really great segue to talk about how the taxes work at death. Um, Here in the office, often we'll have a chat with people and we'll put this on a whiteboard. So it's going to maybe be a little bit harder to do without pictures. But uh, you know, Ben's already commented, like your home, there's no taxes on. Certain things there are no taxes on. And it gets a little bit complicated because there's a differentiation between some things will have no tax, but they will have probate, and vice versa. And so it can get a little bit complicated and messy, but long story short, if we look at two different scenarios, probate, which we already talked about, there is no probate if the beneficiary's named or if there's a joint with right of survivorship holder. There is probate on all the rest. I'm oversimplifying a little bit, but that's sort of basically big picture. That's that cost. Tax wise, it's a little bit more complicated. In some ways better, in some ways worse. Worse because the tax is higher. but your principal residence, you'll never pay tax on that. The or your state won't pay tax on it either. The anything that's like a tax-free account, well, you've already paid tax on it, so it's going to go to that beneficiary, no tax. Uh, the RIF or the RSP, it's as though you sold the whole thing, so and cashed it out. So that is fully taxed. Every dollar that's in there becomes income to you that year. So does any income that you've earned that year, and so does any interest that you've earned that year or rent. All of those things are going to be fully taxed, and so they're all being added up in that same year. And so the year that you pass, unless you have a spouse, some special provisions for if you have a spouse, a lot of that can roll over without any tax consequences temporarily. But on the second passing, that's all going to get hit with tax. Um, and then, yeah, any investments outside of those, to the extent that you have gains, whether it's a rental property or investment accounts, those gains, just like if you sold them while you're alive, you're going to pay tax on half the gains. So, there's all these lists of things that have these different consequences, but you can appreciate that year, it's going to be a big income year and you're going to get hit tax-wise fairly
Well,
hard.
and that's why it's so important to think about it ahead of time.
Yeah,
And so especially like with the RSPs and RIFs and things that are 100% taxable at your income rate. And so I find myself all the time talking with clients and I say, hey, you're in your 70s, you're in your 80s, you're in your 90s, you got this big old RIF account over there. Why don't we start withdrawing that, deregistering it a little bit faster than you have to, just to trigger that tax over multiple years instead of all of it being taxed to the estate? And that's estate planning. We
that's
try to
right.
sneak in a
Yeah.
little bit of estate planning for our clients here and there without them knowing it. So, yeah, just it's important to think about those things, and in many cases has saved our clients tens of thousands, potentially even more in taxes
Absolutely.
and
Yeah.
stuff like that.
Yeah,
So,
that's right.
moving on then. So most of that's about death and taxes, the only sure things. Um, Also wanted to talk about kind of estate planning while alive. Not really an estate planning tool anymore, but because it's
Oh,
lumped in with the will.
hang on one second, just before you leave taxes. I saw
Yes.
a quote the other day from Will Rogers. Um, the funny thing about death and taxes, um, death doesn't get worse every year when Congress meets. So there you
Okay,
go.
yeah, there you
Anyhow,
go.
Will Rogers was US, but there you go.
Yeah, perfect.
All right,
I was
sorry,
going
I
to
didn't
shift
mean to
the
cut you
convo
off.
to powers of attorney, which is more so an estate while, or sorry, more so a tool while you're alive. But typically, in almost every case that I've seen, when you get your will, you also get your power of attorney. They're very often lumped into one grouping, which is probably a good thing because it makes sure that you actually go and do it. But essentially, what the power of attorney is it's giving someone else power to act on your financial affairs. And so, just a standard power of attorney, that's what that is. I said the word financial, and that's important. There's a reason for saying that. Um, you also want to make sure, and I believe most lawyers are going to do this for you, but that standard power of attorney, if you become mentally incapacitated, it no longer serves. And if you die, it no longer functions either. So you want an enduring power of attorney so that at least if you're incapacitated, whoever I have listed to have control over my financial accounts, they can still utilize it. So the thinking here is if I was out of the country for 6 months and I needed someone to manage my accounts, I could name my dad or my brother as my power of attorney. They could sign off on things to do with my banking, things to do with my investments, so on and so forth. If I've got the enduring version, then that still would endure and still be in place, even if I became mentally incapacitated.
I would all say that almost powers of attorney are almost more important than wills. I have
I'd
seen
agree.
not many, but a few situations where people had a will and not a power of attorney, and where the individual became incapacitated, and it was a nightmare. You can go and get a court appointed power of attorney or court appointed attorney, but it's just a lot of work and headache for your loved ones. So the powers of attorney are really, really, really important. If you don't have one, get one. A lot of people don't understand there are limits to what a power of attorney can do. They can't do everything. For example, if you become incapacitated and you haven't named anybody as the beneficiary of your RSP, your power of attorney can't do that. They don't have the authority to do that. There's some weird exceptions. If you have an RSP and you've named a beneficiary and it's got to roll into a RIF, um, we have seen the courts approve the beneficiary to carry through to the RIF. But even that's a little bit iffy. But fortunately, a couple of years ago, we saw that the courts approved that. But it's they can't do everything, but they can do most things, and certainly the things that are the most important. So you do really, really want to make sure they've got it and that you do it before you lose capacity, because as we get older, that risk becomes bigger and bigger and bigger.
Yeah, well, and so far we've been talking about the power of attorney, the regular one for financial situations. There is actually the separate one. So that one alone doesn't cover medical decision making, right? You can get a separate one, which in BC is called a representation agreement. Other provinces, like there's no consistency to what it's named. It might be called the power of attorney for health, medical power of attorney, something along those lines. Um, but essentially, that one would let a loved one make decisions about my medical status. So if I was in a position where I couldn't decide for myself and someone else had to decide, whether to pull the plug or whether to give me this medicine or that medicine or whatever, without it, no one can make that decision for me. You would need to get someone court appointed, which takes some time. It's a delay. Much better would be for me to have that medical power of attorney listed and in place already.
Weirdly, the medical system, at least here in BC, doesn't seem to have the same strict legal, well, no, maybe they have the same strict legal requirements. They don't seem to have the same strict environment that we do in the financial world. It's been my experience that in many cases, that representation agreement isn't actually needed to get lots of stuff done because you can, go to your parents' doctor and they will give you information, even though they probably shouldn't. There seems to be a greater lackadaisical attitude about that than in the financial world. We're very, very, very strict about it. But regardless, certainly when it comes to the really difficult decisions, when push comes to shove, you're going to want to make sure somebody's got that authority to act on your behalf and to make those decisions. So a representation agreement is also just a really good idea. And normally when you go to a lawyer, they're giving you a deal to get all of these done at the same time. They give you a break, usually, not everyone, but in most cases, they just want to do them all at the same time, and they'll give you a break for having a package deal done. So that's the route that you want to go. Somebody you trust, somebody you know well, and yeah, get her done.
Yeah, for sure, for sure. And so yeah, we've talked about a lot of different things already. Um, wills, naming joint survivorship or joint account holders on your stuff, naming beneficiaries, getting a power of attorney, your executor, your guardianship, all of that stuff. So there is a lot to it, and I think there's enough to it to justify that you should probably be reviewing this plan at least every few years. I'd recommend at least every 5 years. Probably most people should be updating all of these documents, reviewing it, taking a look over these things. But then, as well, anytime there's been a major change in your circumstances, if there's been a marriage or a divorce, or you've had kids, or started a business, or anything like that, that's typically a good time to review that and just update it to your plan. And I think the other component to this, we've said before, but it's have that conversation with your family just to avoid surprises. Hey, here's what I'm thinking in terms of my estate. what do you think about this? Here are my expectations for you guys. Clearer communication tends to help a lot with avoiding frustration, avoiding surprises, all of those sorts
Yeah,
of
yeah,
things.
I'm a big fan of that. First off, actually, as Ben said, anytime there's a big change going on, you definitely want to review your will. You also want to be aware that with some big changes, your will becomes invalid. In fact, actually, a lot of people don't know this. The second you get married, your will is no longer, it's void. So if you're anticipating getting married, there are lawyers can draft a will in anticipation of marriage, and so it does continue on past it if you know that's happening in the next year or whatever it is. But but yeah, the second you get married, you got to make sure you have a new will or write one up shortly before in contemplation of. And they know how to do that, obviously. So anytime you have big changes going on, take a look at it, get your lawyer to take a look at it. Most of the time, lawyers are going to look at it for free, in the hopes that you need to update it and they make a buck. So don't be shy about bringing your will to a lawyer and saying, "Hey, is this still good?" And on the communication front, yeah, as Ben said, really, really important to communicate with your family, with your executor. Um, in fact, I have seen firsthand situations where parents gave a very different amount to different kids. And instead of leaving it to them and not saying anything, they had a conversation with them. And they didn't like it, but they ultimately agreed. They understood why the parents were making that decision. And it kept the family together afterwards. Had they not said anything, it probably would have torn the family apart.
Well, yeah, imagine finding that
Yeah,
out. You're
yeah,
grieving because you've lost the parent, and then also at the same time you're finding
yeah,
out that your sibling
yeah.
got something different than you did, or what
Yeah,
have you.
Joe's
So
getting half the money and me and Fred are only getting a quarter each, right? Like, why is that, right? And there might be a valid reason.
yeah, but
Um,
it's hard to imagine there not being an argument, right? And all
exactly,
of that. So
exactly. So,
I think too, I mean, we've mentioned it before, but especially in BC, if you're not documenting these reasons, wills can be pretty contestable. A
yes,
lot of the times the beneficiaries can come
yeah,
back to the estate and try to sue for a better position. So if you can document that here are the reasons, and we've also had this conversation with the family, it significantly lowers the
yeah,
likelihood that happens. Because no one's happy in a case like that when there's
yeah,
a
yeah. I think the last thing I want to touch on, is something that we're bringing back, something we did a long time ago, uh, and we're starting to do more. In fact, actually this year I'm going to be very pushy about it, with my clients. The We periodically will have a chat with the executors, of our clients' wills, and um, uh, just having that conversation, even if it's a 5 minute phone call, is sufficient to break the ice, to make it easier for that executor to reach out when they're not sure about something. And so we have just found that for our clients, it's been a really, really valuable, simple way for us to add value but valuable for that executor, because it just makes it that much easier for them to just pick up the phone, reach out and say, "Hey, what's the deal going on here? Do you know anything about this or that?" Just, that tiny, tiny little step. And so, having your financial planner meet or chat with your executor, well, actually, I would say also, we haven't talked about trusted contact persons, but I would say your trusted contact person. Um, and in some cases, having that family meeting, we did one about a month ago. We had a client in, two of their children were in with their spouses, and the third child couldn't make it to the meeting here because they lived far away, and we had them in on Teams. So in the boardroom here, we had whatever it was, 6, 7 people, and one person online. And we just had this discussion. The parents wanted to make sure that everybody was on board and cool with how things were going on, and that any questions that they had were being answered. And so we just had this really great family meeting, And I think maybe they were a little bit nervous about having it in advance, but they were just tickled pink with the whole thing. And so those kinds of things, they're a little bit difficult to do. You know, it's hard to talk about death, but it really helped the whole family gel
Well,
and be comfortable. Yeah.
and can be hard for the family, like for the parents or whoever it is, to start that conversation and to
Yeah.
know where to
Yeah.
take it. And so I think that's where if we can help facilitate those conversations and say, hey, you should really chat about this, and loop in your executor and the beneficiaries and all of that. Yeah, we're quite happy to help and have those conversations.
Yeah, absolutely. Well, thank you for tuning into this episode of Retire in BC. Estate planning may not be fun to think about, but taking the time to plan now can save your family a ton of stress and ensure that your wishes are actually followed. Remember, it's not just a will, it's about making sure that everything you've worked for is protected and your loved ones are taken care of. If anything we talked about today sparked a question, or if you want help reviewing your estate plan, reach out to us here at VisionVest. We'll help you make it simple and practical. Until next time, take care and start planning today.
Thank you. Bye. The views and opinions expressed in this podcast may not necessarily reflect those of IPC Securities Corporation or IPC Investment Corporation. The information provided is for informational and entertainment purposes only and should not be construed as financial, legal, or tax advice. The hosts and creators of this podcast assume no liability for actions taken based on the content discussed.